Morning everyone, and today you will learn two cases decided by the Supreme Court in 1906 and 1961 in relation to church tax exemption. The first is the Roman Catholic Apostolic Church in the Philippines versus A.W. Hastings. Hastings here is the assessor of Manila and imposed a tax upon the residents of the Roman Catholic Archbishop in Manila. And the physical setup is that the residence of the Archbishop is more or less 80 to 100 meters away from the cathedral and serves as the actual residence of the Archbishop. Now, the question is whether the residence of the Archbishop is exempt from tax. The appellant, Hastings, said that it is not exempt because of three reasons. First, it is not a parsonage and it is not adjacent to the cathedral. And last, exemption privilege is exhausted already by the parsonage of the adjoining chapel, and it is just 8 meters away from the chapel. The Supreme Court said that what is being argued by the petitioner or the appellant is that the parsonage is the Casa Parroquial version of Spain. Like, this is the understanding of Hastings during that time. And if we allow this interpretation, like we adopt the Spanish version, it would not also include the Protestant clergymen or the Jewish rabbis or the Roman Catholic priests not living in the parish houses or not having the parochial status. So the Supreme Court said it is wrong to adopt the Spanish version. And according to a testimony included in the case is that the relations of an archbishop to his cathedral are pastoral in character, and that he is the ecclesiastical dignitary properly having a resident tributary to it. So it is proper for the archbishop to have a residence in near the cathedral. And the word adjacent does not mean contiguous, but according to the Supreme Court, it should be interpreted to mean close or nearby. And based on the evidence presented, the location of the residence of the Archbishop have been chosen as the fittest available site for the purpose. And based on evidence too that the cathedral and the residence here stands on an integral lot, and there's only one lot involved. Okay. Both structures, also the Supreme Court further said, the residence of the Archbishop and the parsonage near the chapels, already exempt, were built independently and at different periods. So this one, the Archbishop residence, is separate and were built on different periods and have distinct privileges and treasuries and officers based on the setup of the Roman Catholic Church. So we could say that the purpose of the Archbishop residence is pure for religious purposes and incidental to the maintenance of the cathedral and the church here in the Philippines. So the Supreme Court finally decided that the tax paid under protest in the amount of more than $1,600 was improperly collected and must be returned to the plaintiff, the Roman Catholic Apostolic Church in the Philippines. So we now go to the second case. The second case is the Commissioner of Internal Revenue versus Church of Jesus Christ, New Jerusalem. What is being the issue here is there's a donation from a certain Nerda Hansen from New York, USA. And the donation involves 2 crates of Chesterfield cigarettes for free distribution among its poor and destitute members, according to the donor. Now, the church requested for exemption but was denied because it was not considered for civic, religious, or charitable purposes. So, the issue here is whether the cigarettes are tax exempt. These are the conditions laid down by the Supreme Court for imported donated products or articles or goods to be exempt. 1. Here, or A, imported articles must have been donated. B, donated consignee, the recipient, must be a duly incorporated or established international civic organization, religious or charitable society, or institution for civic, religious, or charitable purposes. Now, and letter C, or the third requirement or condition, the articles so imported must have been donated for the use of said organization, society, or institution, or for free distribution and not for barter, sale, or hire. And the commissioner said that exemption covers only articles which by their nature are for such required purpose. So a cigarette is not related to charitable or religious purpose. So the Supreme Court said that all three conditions are present, and the enactment of the RA, or Republic Act 1916, granting exemption to imported goods was to encourage the flow of donations, because if you look at it, the timeline was after the World War II, and it was to encourage donations or reliefs or donations from abroad for relief and rehabilitation of the Philippines. Now, what about the proprietary nature of cigarettes given or to the poor and the needy? Is it okay to give cigarettes to the poor? The Supreme Court said there is nothing wrong, basically, of giving cigarettes to the poor and needy. And element of charity is not destroyed when cigarettes are given to the poor. And this is a very good analogy of the Supreme Court, because it said further that donations sent to our soldiers in Korea during the Korean War were in the form of beer and cigarettes, and it was considered as charitable. And even if American cigarettes are highly priced, it does not alter the situation that this is an act of charity, and these cigarettes are ordinary commodities in the United States of America. And given these reasons, the Supreme Court said that the cigarettes donated by Hansen from the US should be exempt from tax. So the Church of Jesus Christ, New Jerusalem, was exempted from paying the tax of the donated goods. So I hope in this very quick lesson you learned something from these two landmark cases. These may be old, but these are still applicable in the present time. Thank you so much for listening, and I hope you will take the quiz on Friday afternoon. Thank you so much. Good day.